my channel, Botswana Thinking Law, where I bring you and the law closer. Are you married? Are you thinking about getting married? Do you know someone who's married? Or someone who's even thinking about marriage? If that's the case, then this is the video for you. Before we get into this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of information. If you need legal advice that's related to your matter, please contact an attorney. Now, back to our topic of today, marriage. Marriage is a specialized contract. And the reason why it is special is because the ordinary rules of contract do not necessarily apply in respect of a marriage. There are three types of marriages in Botswana. They are customary law marriages, common law or civil law marriages, and religious marriages. For purposes of this video, I will only be talking about two types of marriages, which are customary law marriages and civil or common law marriages. So, customary law marriages. How is a customary law marriage concluded? And when I say concluded, I mean when in customary law are people considered to be married? And it might be shocking for a lot of you, but patlo in Setswana is when a customary law marriage is said to have come into existence. So, the groom's family have to go to the bride's family and ask for her hand in marriage. And if the bride's family accepts this request and indeed gives her hand in marriage, then the customary law marriage has come into existence. And it does not matter whether or not bohadi has been paid. As long as the amount of bohadi has been agreed by the family, then the marriage has come into existence. Therefore, once the patlo is finished, the parties are considered to be married under customary law, and they have to register their customary law marriage with a marriage officer. And a marriage officer can be Khosi, because Khosi, in terms of the law, is considered to be an ex officio marriage officer. But in order for the avoidance of any issues, you can take yourself closer to the registrar of marriages offices and inquire in relation to who or which Khosi is a registered marriage officer. So, once people have been married under customary law, the next question becomes, what are the proprietary consequences of a customary law marriage? In other words, who gets what in the event they get divorced or one of the spouses passes away? And the answer to that is, according to customary law, the proprietary consequences of a marriage conducted under customary law are determined by the tribe that the husband belongs to. And the reason why that is because when a woman gets married under customary law, they are considered to have left their tribe and joined the tribe of the husband. And therefore, these proprietary consequences differ from tribe to tribe. And if you are getting married, you would have to inquire in relation to the proprietary consequences of a customary law marriage from the elders and from the Khosi. Now we move to civil marriages. Civil marriages are concluded or they come into existence once the spouses sign their marriage certificate and it is duly witnessed. Before the spouses sign this marriage certificate, they have the right to choose the proprietary consequences of their marriage. And these proprietary consequences will be discussed later on in this video. Once they have signed a document or haven't signed a document to talk about proprietary consequences, that's when they sign the marriage certificate. And once it is witnessed and signed off by the registrar of marriages or his duly appointed officer, then a civil law marriage is considered to have come into existence. So, what are the proprietary consequences of a civil law marriage? A civil law marriage can have parties not sign any document before they get married. If the parties do not sign any document before they get married, and one of the parties is domiciled in Botswana, and when I say domiciled, I'm not talking about citizenship. When a person is said to be domiciled in a certain country, it means they consider that country to be their home. So if a Botswana goes and lives in South Africa and they have no intention of coming back to Botswana, they build their life in South Africa, then they are considered to be domiciled in South Africa. Usually, domicile goes hand in hand with citizenship, but that is not always the case. So if a person is domiciled in Botswana, then when they sign no document, they are considered to be married out of community of property. And if they are considered to be married out of community of property, then the next question is, in this particular situation, marriage out of community of property, what does it mean? And it means that if the spouses want to get divorced, or one of them passes away, how is the property dealt with? If they are married out of community of property, then the question to look at is, if this person was domiciled in Botswana, are they considered to be what is called a tribesman? Do they belong to any tribal community in Botswana? If they do belong to a particular tribal community, then the proprietary consequences of the marriage will be dealt with according to customary law. Belonging to a tribal community does not necessarily make somebody a tribesman. There are various things that the court looks at when the issue of who is a tribesman comes to question. The court at times looks at various factors like the mode of life of these people or the deceased if the spouse has passed away. They look at what assets they have, where the assets are, as well as the relations and relationship they have with their particular tribal community. Therefore, it is possible for someone to be part of a particular tribe, just like I am from Bubira, I am Mira, but that doesn't necessarily make me a tribesman. So the first question is, do you belong to a tribal community? If that question is answered as yes, the next question is, what is your mode of life? Did you live in the city or did you live in the village where the tribal community is close by? What property did you have at the time you passed away or at the time of divorce? These are merely some of the questions that the court will ask and seek to be answered in order to decide whether or not the people involved are tribesmen. If, like I said, the people are tribesmen or the person who has passed away is a tribesman and they haven't signed any document before they got married, then their property is dealt with according to customary law. And the customary law that would apply is the customary law of the husband. Now, the next proprietary issue is when people get married or just before they get married, they can sign a document called a Form A. Now, a Form A is signed where people wish to get married out of community of property. If people decide to get married out of community of property, there are two types of Form A's. You have the Form A that excludes customary law from applying to the proprietary consequences of the marriage, or one that does not exclude customary law. This means that when tribesmen get married and they sign a Form A that does not exclude customary law, then customary law will apply to the proprietary consequences of their marriage. And therefore, when the marriage comes to an end by way of divorce or someone passing away, then the property is dealt with according to customary law as previously discussed. If they exclude customary law, then the property or proprietary consequences are dealt with according to the common law. And we will deal with the common law later in this video. The other form that the parties can sign is what is called a Form B. The Form B relates to marriage in community of property. There are also two types of Form Bs. This is the Form B that includes customary law to the proprietary consequences of the marriage, and there's the Form B that excludes customary law from the proprietary consequences of the marriage. If the parties sign Form B that does not exclude customary law, then upon the termination of the marriage by divorce or the passing away of one of the spouses or both, then customary law will apply in relation to property division. If they do exclude the customary law applying to the proprietary consequences of their marriage, then the common law applies. And we will discuss the common law during the course of this video. The only exception where the people have signed forms that do not exclude customary law is if they sign a will. And we will talk about wills in a future video. So, the next issue is, what are proprietary consequences under common law? Under common law, if people sign a Form A where they exclude customary law, the law is different to that where they sign a Form B also excluding customary law. Form A excluding customary law, the common law says, as these people are married out of community of property, each person keeps what belongs to them. So if the parties are married, they are both working, and each one buys themselves a car, at the time they decide to get divorced, then each one will keep the car that they bought. It is, however, different when it comes to the passing away of one of the spouses. If they are married out of community of property and one of the spouses passes away without leaving a will, the law says the property of that spouse has to be shared between the surviving spouse, and the surviving spouse is the spouse that is still alive, and the children. As an example, if these parties had one child, it means the entire property of the spouse who has passed away is divided into two. So the remaining spouse gets 50% and the child gets 50%. If there are 3 children, then the property is divided into 4. The remaining spouse gets a quarter, and each of the remaining children also get a quarter. If the spouses did not have children, then the law says that the property is to be divided between the remaining spouse, the parents of the person who passed away, and the siblings. In that situation, the remaining spouse gets 50%, and then the parents and the siblings of the person who has passed away divide the other 50% between them. If there are no parents, no children, and no sibling, then the remaining spouse or surviving spouse will get everything from the spouse who has passed away. Remember, this is in a situation where the spouse that has passed away has left no will. And now we get to spouses that are married, signing a Form B and excluding customary law. As previously explained, Form B means people are married in community of property. And this community of property means you share your assets and you share your debts or liabilities. Meaning that if I get married today and I have a car, for example, as soon as I sign that Form B and the marriage certificate is properly executed, then half of that car will belong to my spouse. Similarly, if I owe 100 pula, at the time I sign this Form B and we execute the marriage certificate, then it means I owe 50 pula and my spouse owes another 50 pula. So community of property is not only about assets, but debt or liabilities as well. So, if a spouse that is married under community of property passes away and they leave no will, the law provides that the remaining spouse, because he or she already owns 50%, they take their own 50%. And then the 50% that remains is supposed to be shared between that spouse and the children. Therefore, as an example, if these people had one child at the time of the passing of one of the spouses, then the 50% that belonged to the spouse that passed away is shared equally equally between the spouse that remains and the child. So the child will take 25% and the remaining spouse will take the other 25% to make a total of 75% because they all have already taken the 50% that by law belongs to them. As another example, if there are 3 children of the marriage and the spouse passes away without a will, the spouse that remains will keep their 50%. The other 50% will be divided into 4, being the 3 children and the remaining spouse. Therefore, they would each get 12.5% of the estate. And when you add the 50% that the spouse has already, that would become 62.5% that goes to the remaining spouse. And I reiterate again that this is in the event that there is no will left and where the parties have signed a form to exclude customary law. On the issue of division in relation to children, the law has to be clarified. When a woman has a child before they get married, and they get married to a different man, and they have another child, if that woman passes away, then her share of the estate has to be divided between the spouse and the children, one being the one she had before she got married, and the other one she had during the marriage. So her share would be divided into 3. And this is the situation whether she is married in or out of community of property. In respect of children and men, the story is different. If a child is born out of wedlock to a man, then that child does not have an automatic right to inherit from him. And that is the reason why a man who has a child out of wedlock should leave a will to leave property for that child. However, this position of the law has not yet been challenged in light of the Children's Act, which seems to be saying that children cannot be disinherited. If a man has children within a marriage, then those children have the right to inherit, even if the children or the parents end up getting divorced. It is clear that this law is discriminating on the basis of gender, and according to this law, as it is still valid and appears not to have been challenged, this automatic right to inherit for children only arises in respect of women generally, married and unmarried, but only arises in respect of men when they had children, when they were married, unless they officially adopt their children born out of wedlock. The next question then becomes, when parties get married and they sign this Form A or Form B, can they then change the situation at a later date? And the answer is yes. Parties that get married have the choice to change their proprietary regime during their marriage, but they can only do it twice. So, if people are married in community of property and they want to change, they can change to out of community of property. If people choose to change into out of community of property, they can then later change back to in community of property. But that would be the end of their ability to change their marital or proprietary regime during that particular marriage. But if people get divorced and then sometime down the line they decide to marry again, then those two chances to change the proprietary regime are there again. When people choose to change their proprietary regime from either in to out or out to in, there are various processes that have to be followed. And the reason for these processes is because there are certain rights and duties that come from the different types of proprietary regime, especially in relation to creditors. People have to tell the people that they owe if they intend to change their marital or proprietary regime. They have to advertise in the newspapers and government gazette that they intend to approach the court, and the court here being the High Court, to change their proprietary regime. And then they have to put in copies of these adverts in their application to court. I do not advise people to undertake this process by themselves. They should engage the services of an attorney or lawyer so that they can get assistance that is specific to their matter. When people are married, whether it is in community of property or out of community of property, they owe each other a duty of care or support. Meaning that if a husband is not working and his wife has a job, then she has to look after him for as long as they are married. And also, if a man has a job and his wife does not, the law says that he should look after her for as long as they are married. Further, if people who are married have children, then the law presumes that those children are the children of the marriage until something different is demonstrated. So, if a child is born in a marriage, that child is considered to be the child of the mother and father or husband and wife until something different can be shown. Having said that, people should enter into marriage with a full consideration of what it is that they are entering into and what it is that they wish to be the proprietary consequences of their marriage. One of the things that people can look at, aside from the signing of the Form A, Form B, or not signing a document, is preparing a document called an ante-nuptial contract. And in this ante-nuptial contract, people will be saying what property they want to be in community of property for, or what they want to be excluded, and so on and so forth. Again, please get the services of an attorney if you wish to enter into an ante-nuptial contract so that they can explain to you the different considerations when it comes to ante-nuptial contracts and whether it would make your marriage in or out of community of property and so on and so forth. The next question is, a marriage come to an end? A marriage comes to an end one of two ways: by divorce or by the death of one or both spouses. When the spouses want to put an end to their marriage, if it is a customary law marriage, the law says if the couple goes to their families and the families agree that the marriage has come to an end, they can bring the situation to the Khosi for confirmation, and that will be the end of the marriage. However, for civil or common law marriage, divorce has to be done at the High Court, where the court will give out an order for the divorce between the parties. At the time of the divorce, either at the customary law or at the High Court, the court will also deal with who gets to take what from the marriage based on the law. If the parties are married and they have Form A or a Form B, the court will look at whether or not these forms excluded customary law. If they did not exclude customary law, then this property would be divided according to the law of the particular tribe of the husband. If the Form A or B excluded customary law, then at the time of the divorce, the court would divide the property according to the proprietary regime. Meaning that if parties signed a Form A, then the court will divide the property according to who owns what. However, this is not the end of the story, because one of the spouses can claim what is called universal partnership, when they say, while you were working, making money to buy cars and houses, I was at home looking after the children. And because of that, I was not able to go to work in order to buy all this property. Therefore, I am entitled to a part of the property that you have gotten, because without me, you wouldn't have been free to get that property if I wasn't looking after the children. Sometimes they can argue that they contributed an amount of money. And these are the things that the court would look at in dividing property where people have signed a Form A and they have excluded customary law. Where the parties have signed a Form B, then everything has to be put together and divided in half, where one party or spouse takes 50% and the other party or spouse takes another 50%. However, if the parties agree to a division that is different from this, then the court will not force something different on the parties. When people get divorced, especially those who are married under Form B or community of property, they have to consider that divorce does not bring their debts or liabilities to an end. If one of the parties or spouses, whether the other spouse knew or not, goes to get a loan and buys a house, a car, or just uses the money however they wish, then even if they are divorced, if the loan was from a bank or any other lender, this lender or bank can go after the spouses. Even after divorce, they can sue both the husband and the wife for the recovery of the money. And it does not matter whether or not the spouses agreed on who is to take the loan, as long as the loan is not being paid or serviced. In other words, if a loan goes to a husband on divorce and the husband defaults on the loan, whether the default came a year or 2 years after the divorce, the bank can still go after the wife to get money to pay back the loan. It is also true if the loan were taken by the wife. And this is an important aspect of community of property. It does not make any difference whether the husband or the wife knew at the time the loan was taken, as long as the marriage was in community of property. Yes, if a loan was taken without the other spouse knowing, then the spouses can sue each other and the property can be divided in such a way to recognize that this loan was taken without the consent of the other spouse. However, this lack of consent does not concern the creditor or the bank or whoever the loan was taken from. Because remember, community of property is community of profit and loss, which means it includes debt. Therefore, if you're considering getting married, weigh your options. Know what your rights and duties are. If you have gotten useful information from this video, please like, share, and subscribe. Leave comments down below with what you thought of the video, what other topics you'd like me to talk about in future videos, and don't forget to always get the advice of a lawyer on legal issues. Thank you, and I hope to see you in my next video. Bye!